Oh, he just went to go grab some water.
She said to come back at 10:30.
Yes.
It is closed, yeah. It's closed. It's hot in the hallway.
They're gonna be happy.
It is hot. Judge, I think we needed a new CLO.
She's complaining about it being too cold.
I wasn't complaining. You sit here with me? Yeah. I'm corner. See?
Oh.
No, new court staff. All the way around. No, I don't have socks.
It's the socks. There you go.
Over here.
Just 1 second. Mr. Cox, are you having anybody sit with you or no?
No, ma'am.
Okay. All right, we're ready.
And if you're gonna bring them in, last time we see a judge, we're on the record. The court said that I couldn't.
Yes, we can go on the record.
Sure. Court said I couldn't. My practice has always been to have the jury come in. I can see where they line up before I ask for a shuffle. If the court rules that I can't do that, then I have to preempt my shuffle. I would like to see them first, but if I can't do that, then I'll ask for a shuffle now.
Right. Let them know it's going to be a shuffle. No, yes, call for a shuffle. Gonna go on the record. All right, so all of the jurors are here with the exception to juror number 18. And that was previously juror number 74. Is there any objection from the state or the defense to excusing juror number 18?
Not from the state, Your Honor.
No, Your Honor. Number 18, that's 18, correct?
Yes. Number 18 was previously juror number 74.
We might just put them on first. I have no clue where we're gonna be at. Sure, I guess. Two 30, 19, we don't know where we're at. Okay.
Council, I'm gonna have you all come back at 1:30. Come back at 1:30
Okay,
because we're about to start jury selection.
yeah, would you tell us to report back over there at 10:30?
No, come back here at 1:30. Where are you reporting to at 10:30?
Pardon me?
You said you're coming back to this court at 10:30?
Yes,
All right, come back at 1:30, okay?
okay.
We're starting jury selection a little later than anticipated. So, Mr. Vale, if you'll come back at 1:30.
1:30, Judge?
Yes.
Okay.
All right, thank you.
1:30, Judge?
Yes.
Okay.
Yeah.
Hello,
How much time before you bring in the journal?
they're coming in right now.
And I have a bunch of motions to fill out. What would you advise me to do on that? Because I'm starting a new job on Monday.
Come back at 1:30.
1:30? Okay.
Yes.
Good.
You're welcome.
Yeah. he's in Dublin.
Yes. Mhm. Beautiful. Sure. And Mr. Cox. Mr. Cox. Can you come up?
All right, for the jury. First chair, first row. Have a seat. Okay. Number 8. Second row on top. First person on the bench.
Good morning, everyone.
Good morning.
Right, that's rather lackluster. Where's the middle of the week? It's not Monday, so that sucks to be excited. Good morning, everyone.
Oh, that is so much better. So you are in the 187 District Court. My name is Judge Stephanie Boyd. You are on the 4th floor in the 187 District Court with Judge Stephanie Boyd. So what floor are you on? What courtroom? And who's the judge?
Stephanie Boyd.
Now, I know what you're saying. Why are you asking us such simple questions? The reason why I ask that and always have everybody to repeat it is because we cannot have jury selection unless you are all here. And whenever we take a break, when we take a break, all the jurors or potential jurors must leave the courtroom. And we've had instances where jurors don't come back. We've had some jurors, they're on another jury panel, not realizing they're not in the 187 District Court. And then we've had some jurors say, I looked up and everybody was gone and I didn't remember where I was supposed to be. So if you ever get lost or we're on a break and you look up and everybody has left you, you need to remember the 187 District Court, or if you remember Judge Boyd, I'm the only Judge Boyd in the entire courthouse. And know that if you are at the courthouse with the green rooftop, you are in the wrong building. Okay. So I'm going to let the parties introduce themselves to you for the state.
Daniel S. Voir from the state of Texas. And Jason Garahan.
And for the defense.
Cornelius Cox.
Joseph Harris.
All right. And
Austin Hagee. I'll be assisting with jury selection today. I'm also a defense attorney.
oh,
Hannah Hawkins.
and everyone, I'm going to have you all keep your voices up because the court reporter is taking down everything that everyone is saying. All right. So to my left is the court reporter. I always, when possible, try to make people's job as easy as possible. I always said when I was working for somebody else, why can't they make this job easier? So to make the court reporter's job easy for her, because she's taking down everything that everyone says. And if you can imagine, some people whisper, some people talk quickly, some people talk slow, and she has to keep up with all of that. And she has to take down everything that everyone is saying. So to make it easier for her, everyone, you need to speak up because the acoustics in the courtroom is not great so that she can hear you. So please do not whisper. In your possession, you have cards. Could everyone please raise your cards? Don't lower your cards until I tell you to lower your cards. Everyone in this jury box, please lower your card. Everyone on the front row here, please lower your card. If your card is still raised, what that means, if possible, whenever you're answering a question, you need to stand up so that the court reporter can hear. Now, I've said this many a time. We have a trial in this court usually every week. So far, no jury has been able to follow those instructions. I have faith in this panel that anybody who has their card raised will stand when they are asked a question. So will everyone be able to do that?
Yes.
All right. If you see the person next to you not standing, just give them a little nudge. Tell them you don't want to fail this assignment. All right, everyone, you can lower your cards. Now, with regards to those cards, both attorneys will have a chance to speak to you. If there's something you would like to answer before answering it, raise your card. They're going to refer to you by your number, and then you can speak. Now, Diana can take down two people talking at once, but if we all talk at the same time, that's going to make her job more difficult, and we don't want to do that. We're going to make it easy for her today. So what that means is only one person speaks at a time. Does everyone understand?
Yes.
Now, the parties have introduced themselves to you. Do any of you recognize or know any of those parties? If you do, raise your card. All right, the charge in this case is murder. And I know what people are saying. People are always, why couldn't I get a car accident? Why couldn't I be on the civil side? Well, cases need to be tried. In order for cases to be tried, we need jurors. Does everyone understand?
Yes.
So when both sides ask you questions, what should be at your forefront of your mind is whether or not whatever decision, if you're selected on this jury, you come to is based upon the evidence that you hear inside the courtroom. Does everyone understand?
Yes.
Now, each party is going to talk to you about hypotheticals. They are not allowed to tell you what they think the evidence is during jury selection. So I know sometimes people want to know certain things about a case. You're not allowed to know anything about this specific case unless you're on the jury. So neither the state or the defense are going to get a chance to, I would say, spin for you what they think the facts are. Every question that they ask you is a hypothetical. Does everyone understand?
Yes.
Now, I want to talk to you about two other things as well. You will see people sitting here. Sometimes the people who are sitting here are students who are trying to make a decision whether they want to be an attorney or not. Sometimes we have people who are trying to make a decision whether or not they want to be a court reporter. But the people who come through that door didn't read the sign on the outside that says, do not come through this door, we're in a jury trial. So they will probably peek their head in and then sheepishly go out. People who come through this door are staff, or maybe they have documents for me to sign. But what I want you to know, people who are coming through this door or this door have absolutely nothing to do with this case. Sometimes you may see officers come through this door. Again, that's something for me to sign that is unrelated to this case. Does everyone understand?
Yeah.
Now, I want to talk to you about an indictment and what that means. And I'm going to give you some practice in raising your card. How many people in here have ever had a traffic ticket? Don't be shy. All right, so we have a lot of bad drivers in here. There's maybe one who's had no traffic ticket. So when you get a traffic ticket, say, for example, somebody said you didn't follow the yield sign, which I've discovered nobody in San Antonio knows what the yield sign actually means. But let's say it's the yield sign and the officer pulls you over. When I was growing up, I've had one ticket in my life. When I was growing up, they had their paper book and they would write the ticket, hand it to you. You'd sign it, acknowledging that you received it. When that officer gives you that ticket and you accept that ticket, you are not saying, yeah, you're right, I ran the yield sign or I didn't follow the yield sign. What that ticket is telling you is, this is what I'm saying you did. This is where you need to go to answer for it. It's not, and the fact that you're receiving that ticket is not an evidence of guilt against you. Does everyone understand?
Yes.
So it's the same way with an indictment. An indictment is not evidence of guilt. It cannot be taken by you to mean anything. An indictment is just the means whereby somebody says, you're coming to felony court. This is what we're charging you with, and you have a jury trial. Does everyone understand?
Yes.
So you cannot hold it against Mr. Harris or take it in consideration whatsoever, the fact that he's here under indictment. Does everyone understand? Is there anyone here who cannot follow that instruction? Next thing I want to talk to you is certain rights that people who are accused of a crime have. One of them is the right to remain silent. Has everyone heard of that before?
Yes.
All right. So I see I have a lot of Beretta, Mannix, and Barnaby Jones people here. Where am I? Wait, where are my Mannix? And thank you, 39. Everybody else is pretending they've never seen that. And I'm sorry, number 65. Thank you. So the right to remain silent. Anybody who's accused of a crime has a right to remain silent. That means they have a right not to testify if they don't want to testify. There are many reasons why somebody would not testify. I've been a defense attorney. I've been a prosecutor. Sometimes as a defense attorney with my clients, I would say the state hasn't proved anything. You don't need to testify. Sometimes my clients were super nervous, super shy. I even had clients who stuttered and they would just not be comfortable on the witness stand. So there are many reasons why people may choose not to testify. The key point is you are not allowed to hold it against anyone if they decide they're not going to testify. Does everyone understand?
Yes.
Is there anyone here who would hold it against Mr. Harris if he decided not to testify? Raise your card if you feel that way. All right. The next thing I want to talk to you about is presumption of innocence. Everyone who is charged with the crime in the United States is presumed to be innocent. What does that mean? That means that right now, if you had to vote on whether Mr. Harris was guilty or not guilty, it should be not guilty because you have no information about this case. Does everyone understand that?
Yes.
So at this point in time, is there anyone here who would not be able to find Mr. Harris not guilty right now at this point? All right. So, and that's because you have not heard anything about this case. So with the presumption of innocence and the fact that you have not heard anything about this case, that means that the state has the burden of proof. The defense does not have to prove anything. If you are ever deliberating on a jury and you start asking yourself, well, I wonder why the defense didn't bring this, or I wonder why the defense didn't do that, you know that you have shifted the burden of proof to the defense. And that burden never shifts. It's always with the state. The state has to prove its case beyond a reasonable doubt. When I was in law school, they would tell you defense attorneys can play video games, they can read crossword puzzles, they can do coloring books, whatever, because they don't have to prove anything. Now, of course, as defense attorneys, we never would be doing crossword puzzles or playing games because you're listening to everything. But our professors would tell us that to make us really and truly understand that the defense does not have to prove anything. They do not have the burden. The state has the burden, and that burden, the proof is proof beyond a reasonable doubt. Now, the next question that people will ask me, well, Stephanie, what does proof beyond a reasonable doubt mean? When I was in law school and I graduated, during my first trial, there was a definition for proof beyond a reasonable doubt. you had to remember it and memorize it. And you thought you were the cat's meow for memorizing that. And I knew it forward and backwards. I knew where to pause with the comma. I knew where the semicolon went. I knew where to put the exclamation point. And then after my first trial, there is no longer a definition for proof beyond a reasonable doubt. So the state cannot give you definition and defense cannot give you a definition because there is no definition. So as my time as a defense attorney and prosecutor, I would tell people what it was not. So in the building next door, the historic courthouse with the green rooftop, they handle civil cases. And their burdens of proof over there is preponderance of the evidence, which is more likely than not something happened. So if you're ever in a criminal court and you're deliberating and you're saying, well, I believe maybe that happened more likely than not, you are not at the proper burden of proof. You're at the civil burden of proof. Does everyone understand?
Yes.
Now, the other burden of proof that they have over there is what's called clear and convincing evidence. Clear and convincing evidence is the evidence that's used when somebody wants to terminate your parental rights. They're saying you're a bad parent, you're a danger to your child, so we're going to terminate your rights, and legally you will no longer be that person's parent. That's a high burden. But there's a burden that's higher than that burden, and that burden is proof beyond a reasonable doubt. It's the highest burden that we have in Texas. Does everyone understand?
Yes.
Now, there are two phases to a jury trial. The first phase, people call it guilt innocence. It's really not guilt innocence. The first phase is really guilty, not guilty. You're not finding somebody innocent. You're making a determination on whether the state proved their case or did not prove their case. So that's phase one. Phase two is called the punishment phase. You do not get to the punishment phase unless you've found someone guilty. Does everyone understand?
Yes.
All right. So our law states that anybody who's charged with a criminal offense, they have to make an election or selection that if they were found guilty, who would decide punishment? That doesn't mean that they're guilty. That just means that the law says they have to make a selection that if they were found guilty, who would they like to go to for punishment? In this case, Mr. Harris has decided if he were found guilty, he would go to the jury for punishment. Is there anyone who's going to hold it against Mr. Harris for selecting that if he were found guilty, he would go to the jury for punishment? Okay. Now, is there anyone here who, for religious reasons or other reasons, cannot sit in judgment? All right. Number 23, anyone else? 13, 43, and 49. The next thing I want to talk to you all about is languages. I love languages. I think they're beautiful. In my undergrad and grad school and law school, there were many students from all over the world. They spoke many languages. One of my classmates spoke 6 languages. I just think it's awesome. They were teaching me different languages. I had no idea I would end up in San Antonio. So of course, the other language I learned was French. My classmate tried to talk me into learning Spanish, but I'm like, no, I'm going to be retired at 23. I'm going to be living in Paris. Well, as you can see, here I am, 24, and okay, that shouldn't be that much laughter. It should be, oh my gosh, she's so intelligent. She's only 24. But so I decided to take French. I didn't take Spanish, which I should have done, obviously. So all of my classmates, I could probably say hurry up in probably 10 languages, because that's the only thing that I could pick up from them. So is there anyone here, raise your card, if English is not your first language? And keep your cards raised until I call your number. 8, 9, 13, 28, 44, 48, 50, 53, 54, and 74. All right, juror number 8, what is your first language?
Filipino.
We've had Filipino in here before. So how do you say hurry up? I put you on the spot. Don't be nervous. All right, thank you. So have you been able to understand everything that's been said?
Yes.
All right, thank you. Number 9.
My first language was Spanish.
Mhm.
I am fully bilingual. And I understand everything that's being said. And apresúrate.
Oh, thank you. Number 13. Your first language?
Spanish.
All right, have you been able to understand everything? Did she tell me how to say hurry up correctly?
Yes, but I say it in a different way. I say apúrate.
Ah, thank you. All right, number 28, thank you. 28. Somebody nudge number 28. Yes.
My first language is Spanish.
All right, have you been able to understand everything?
Yes.
All right, thank you. Number 44. Yes. All right, could you speak up a little bit, please? All right, have you been able to understand everything? All right, thank you. Number 48.
My first language is Filipino, dialect Cebuano.
Okay, so here's the thing with the dialect, if you could spell that for the court reporter.
Dialect, D.
No, not the word dialect. What came after that?
Cebuano,
Yes.
Cebuano,
How do you spell that?
CEBUANE.
Thank you.
Cebuano.
So have you been able to understand everything?
There's 2 words that I'm not really understanding it well, like the indictment
Okay.
Yeah.
And what other word?
and reasonable doubt.
Okay. All right. Well, we don't have a definition for reasonable doubt. All right. And did he tell me how to say hurry up correctly?
In his dialect, it is correct.
Okay. Thank you so much. Number 50. Yes.
My first language is Russian.
Okay. This is the first time we've had Russian. So have you been able to understand everything? How do you say hurry up in Russian? All right. Repeat that again. All right. Thank you. Number 53. Yes.
First language is Spanish.
All right. And have you been able to understand everything?
Yes.
All right. Thank you. 54.
Also Spanish?
And have you been able to understand everything?
Yes.
All right. 74.
Spanish.
And have you been able to understand everything?
Yes.
All right. Thank you. All right. The next thing I want to talk to you all about is travel arrangements. Is there anyone who has something that's coming up? You can't exchange it. You have flights. You can't put it in my name, anything of that nature. Please raise your card. And once I call your number, you can lower your card. All right. Number 1, and the person next to your card isn't turned. 2, 8, 12, 13, 14, 16, 21. All right. See, y'all got to raise the card when I call. All right. Number 4, 31, 36, 42, 43, 45, 54, 55, 60, 57, 63, 68, and 70. All right. Juror number 1, what's your issue?
I didn't say it's travel issues, it's more of a.
Okay.
I didn't know if that was
All right, commuting from,
home to here, to the jury.
okay. All right, thank you. Number 2.
I'm supposed to go to Seattle tomorrow through next Tuesday.
All right, what are you doing in Seattle? Is it to do the Twilight tour? What are you doing?
It's a Spartan race.
Spartan race. Are you in the race? Okay. And when are you going to that?
The actual race is on Sunday. My flight leaves tomorrow at 6 a.m.
Okay. Number 8. I'm sorry, not number 8, number 4.
This might be a little farther out, but I have a pharmacy conference in Boston in October. It's not till the 10th to the 16th.
All right, thank you. Number 8.
The river Viking cruise, Paris to Switzerland, leaving this Friday, 15 days.
All right, I have friends who are stuck in Europe right now. There was some kind of strike. So maybe we want to check on that. But the Viking cruise, Paris to Switzerland, okay. Number 12.
Question, does that include obligations for minor children?
What is the obligation?
Well, like today, kids get out at early release, so it's at 3:30, so.
All right, thank you. Number 13.
Have a family reunion in Mexico.
All right, do you really want to go to the family reunion? Sometimes people are like, you can tell them, judge won't let me go. All right.
Yeah.
All right, September 29th.
Yes.
Where in Mexico? All right. I may have to drop by. We shall see. All right, number 14.
Have the doctor's appointment.
What time? 21. I'm sorry, not 21, 16. 16?
I'm sorry, I have a work conference in Dallas, next Sunday through Wednesday. Maybe with
What at work?
in the city of San Antonio Economic Development Conference.
Is there going to be a conference about the roads not? Okay. 21.
I have a cruise the week of November the 5th. I don't know how.
Where are you going?
It is going to, it's out of Galveston. It goes to Mexico
Okay.
twice, I believe, and under.
All right. Well, I don't anticipate us being here November 5th, but sometimes jurors like to tell us that so we can get jealous. Yeah. Number 31.
Going to see Beyonce.
Who are you seeing?
Beyonce.
All right. Next week, what date?
I'm sorry,
What date?
the 22nd or the 23rd.
And do you have to wear silver for that, or?
That's what she said, yeah.
So are you gonna wear silver and go on mute?
I am.
Okay. And when will you be back?
The 26th.
Okay. All right, thank you. Number 36.
I'm traveling to Tyler, Texas
All right, when?
on Friday, next Friday.
Next Friday?
Yes.
And what are you doing in Tyler, Texas?
I'm running the Piney Woods Ultra.
I'm sorry, what?
I'm running the Piney Woods Ultra.
Oh, you're
at
running.
25K.
Oh, hey, you need to talk to her. All right, thank you. Number 42.
I have a scheduled work trip on the 25th, but that entire week. Be on the 25th through the 1st to Oklahoma and Arkansas.
Okay. Thank you. Number 43.
Scheduled work trip for tonight through probably next Wednesday.
And what are you doing for work? What is this work trip about?
I'm teaching others the job that I do. Not sure how to,
I mean, should you be teaching others how to do your job?
I'm pretty good at it if I say so myself. Yeah.
Well, no, I mean, but then that makes you
That makes me.
dispensable.
I'm a senior quality assurance analyst.
Okay, all right, thank you. Number 45.
I have a doctor's appointment tomorrow and Friday I'm leaving for San Diego for 4 days.
What are you doing in San Diego? Okay, I'm sorry to hear that. Number 54,
Traveling on the 22nd through the 26th to Phoenix. Gonna go see the Cowboys play,
who are they playing?
the Cardinals. Phoenix,
I mean, are they gonna win that game?
that's fun though.
You're not gonna jinx it?
Oh, that-
Okay. Number 55,
Leaving tonight to go to Oklahoma and I'm not gonna be back.
all right, what are you doing in Oklahoma? Oh, I'm sorry to hear that. I know everything is gonna go well.
Yeah.
All right, number 60,
I'll be going to Vegas next Friday through Sunday.
and what are you doing in Vegas?
Just for fun.
All right. Okay. All right, thank you. Number 63. 63. Yes.
I'm going to Colorado on the 23rd through the 22nd.
What are you doing in Colorado? Thank you. Number 57.
I have a work trip in Orlando, the 26th through the 29th.
And what is the work trip about?
It's a store manager conference.
All right, thank you. Number 68.
My wife has back and hip injections on Monday. And then we have one car, so I have to take her, make sure she's good after that. And my son has his 4-year-old shots on Wednesday.
All right, thank you. Number 70.
I have two kids that are in pick up from school today, and my kids have doctors next Friday,
And what time do you have to do pickup?
3:30.
Are you guys gonna get a ride together? All right, thank you. All right, so all of you, yes. Oh, see now everybody's like, nothing happened to them, so let me raise my card.
I have a daughter who's having eye surgery on the 20th
Okay,
of this month. I need to be with her. She's divorced. And so
Okay.
I'm taking her through the surgery. And then, and that's the 20th of September and the 20th of October. My younger daughter gets induced in Houston.
okay. All right, thank you. And that was juror number 9. Number 11? Yes, 11.
Mine was also the same as this gentleman. My kids also get out early today, early release today and tomorrow.
Okay. All right. Number 52.
I wasn't sure how long to anticipate the trial to last, so when I heard you talking about October.
Oh, no, this is not going to October.
Okay.
All right, thank you. 53.
Thing, I misunderstood the timeline.
All right.
It's about October.
Yeah. Usually when people start talking about, oh, I'm doing this in October, November, they just want us to be jealous. Number 50.
I have 21st, I have a walkthrough with my client in Frisco, Texas, and I have showings next weekend. I sell real estate, so I have 2 more. And I
Okay.
don't have evenings under me.
Okay, all right, thank you. 62.
I apologize, Your Honor. I was thinking you were just talking about travel. My daughter tomorrow has an appointment with a pediatric dentist for wisdom teeth consultation. She needs that surgery in the next month.
All right, and what time is that?
It's at 2 o'clock tomorrow.
All right, thank you. All right, so you've had a chance to see each other. Is there anyone here who knows somebody on this panel other than standing out in the hallway with them or meeting them downstairs? Number 39 and 16. It would have been bad if there was only one person's card raised. All right. Number 39, who do you know?
By panel, you mean jurors?
Yes.
And I didn't remember why, but then I heard your name called. We used to CrossFit together.
Ah, okay. Thank you. So do you know her?
Yes.
Oh, wait a minute. It's 39 and what's your number?
7?
Number 7. You know her
Yes.
from CrossFit.
Yes.
All right, 16, who do you know?
Might be embarrassing. I think Paxton Smith.
Paxton, where are you? Number 73. How do you all know each other?
I've met him through,
All right, Paxton, do you know him? He knows.
No.
All right, and there's no bad, and there's no bad feeling. Okay,
There is now.
all right. So before I turn it over to the state to begin their voir dire, if anyone ever needs a break, just raise your card and let us know that you need a break, or either if you'll just do this sign, I will either see it or the attorneys or somebody will see it and tell me you need a break. But remember, when one person goes on break, then you all have to go on break. I want to tell you all 2 true stories because I understand that jury duty is a hassle. And I always tell people jury duty is inconvenience, is not a sacrifice. And the reason why I tell people this is that my mom grew up in a little town in Louisiana called Grand Cane, Louisiana. I think in its heyday, it had a population of a little bit over 1,000 people. So my grandmother's firstborn, my mother's brother, was super intelligent, and they would just pass him through school. So teachers would just pass him. And when my mother and her sisters came behind him, all the teachers would say, "We know your brother, so we're expecting a lot from you all." So my uncle ends up graduating. He graduates early. Vietnam War breaks out. And he tells my grandmother that I'm just going to go ahead and sign up because they're drafting all the boys from Grand Cane anyway. But my grandmother was going to have to sign for him to go off to war. And if you can imagine, now we have technology. Now we have great phones, we have computers and all of that. Back in the day with my grandmother, their phone number was 4 numbers, and you would have to call the operator and you tell the operator who you want to speak to, and the operator would connect you. There wasn't any of this, oh, let me just pull out my cell phone. Oh, let me just see what's going on. There was no internet. So my grandmother ended up signing for him to go off to war. And I say that was a big sacrifice for her because 1, it's her firstborn. 2, they're being sent off to someplace she's never heard of before. And 3, once he left on the bus, it's like, did he make it okay? You got to send a letter, and that's super snail mail. And then you finally get a letter back, months later, oh, he made it here. And then you're worrying because you're watching on the news. And that was back in the day when your television only had 3 stations and NBC didn't work half the time. And the others, they cut off at midnight, I think, or 11. You just see the flag being waved and that's it. So that was a sacrifice for her, sending him off, not knowing if he was going to come back and what was going to be up with him. And the reason why I bring that story up is because people tend to complain about jury duty, but it's not a sacrifice, it's an inconvenience. Your country doesn't ask anything of you but jury duty and pay your taxes. Now, I know coming downtown, there's a lot of one-ways. When you're driving downtown and you're new to downtown, you're like, the building is right there. If I could just make this right turn, I would be right there. And you have to go all the way around. I understand that parking is a hassle. I understand that people say, you know what, I'm coming down to do jury duty, parking should be free. I understand all of that. But in the big scheme of things, it's an inconvenience. Nobody's drafting you to go fight in a war unless they change things. But my uncle, as somebody who was underage, went to Vietnam and my grandmother signed for him. That was a sacrifice. The other thing I want to talk to you about is speaking. Both the defense and the state are going to have a limited amount of time to talk to you. And in that time, they're trying to find out if you will be great jurors for this specific trial. And remember, anything that they asked of you, basically what they're trying to find out is if you were selected to be on this jury, that you will be able to listen to the evidence and make a decision on whether or not someone's guilty or not guilty based upon the evidence that you hear. Everybody has something that has happened in their past that maybe sits with them. But the question is whether or not you could listen to the evidence and make a decision based upon the evidence that you hear. Does everyone understand?
Yes.
Now, one thing I forgot to talk to you about is range of punishment. In murder cases, the range of punishment is anywhere from 5 to 99 years or life in prison if somebody is found guilty. That is a wide range because you're looking at 5, 6, 7, 8, 9, 10, all the way up to 99 years or life. If you're on the jury, you need to, if someone were found guilty of murder, not this case, but in any case, you would need to be able to consider the full range of punishment. Not give it because you don't know any evidence about the case. But for example, sometimes you have cases where you have a couple who've been married all their life. They love each other. There's no question that they love each other. And maybe the wife or the husband has a terminal illness and they're in constant pain. And they're like, please help me. I just want to end everything. And that person may say, okay, I'm going to help you out. Here's some pills. Here's some water. That's a murder. Now, is that a person that you think should be getting life in prison? Maybe they deserve 5, or maybe they deserve 6. Does everyone understand? So there are all different types of scenarios where you could see where maybe someone deserves 5 years, 6 years, 7 years, life. Does everyone understand?
Yes.
So with range of punishment, you need to be able to consider the entire range. Now, with talking to the state and the defense, one of my friends from law school decided to practice civil law. I always wanted to do criminal law. That was my passion. So civil attorneys usually are not in court that much. On the criminal side, we're usually in court every single day. You're trying a case, you're doing motions or something of that nature. So she said she had jury duty. Let's do lunch. I'm thinking, great. We haven't seen each other in a while. So on her break for lunch, we talk and I ask her, how's everything going? And she's like, it's going fabulous. Now that I've been judged, I'm like, how can it be fabulous? You're not in court with me. But I said, what do you mean it's fabulous? She said, it's just like when I was in law school. She's like, I'm sitting on the back row. I'm keeping my head down. I'm not saying anything. So I laughed. She's like, what's so funny? I'm like, you're still going to be on the jury. So other than raising your hand saying, please allow me to sit on this jury, the best way to get selected on this jury is not to say anything. All right. So with that being said, I'm going to turn it over to the state. State, are you ready to proceed?
Yes, you are.
All right, you may proceed.
Thank you. Well, we're lawyers, we talk a lot, so get ready for that, all right? Who likes lawyers here? Like it up the panel, Judge. All right. I introduced myself earlier. I'm Jason Garahan. This is Daniel Escobar. We represent the state of Texas. And really what the judge was harping on and talking about and really went into depth about is, one, this is jury selection. You're asked to do a few things, she said, or a couple things. One, jury select or JURY service, and then also pay taxes. Well, I'll tell you this, how many times have you seen, especially with these elections in the last few years, I'm the MTV generation, so it was like rock the vote, make sure you go out and vote. I mean, everybody hears that, right? You see it on TV. Does everybody pretty much see that? I see you shaking heads. Everybody says that, please vote, make sure you vote. However, a lot of people don't say, please sit on the jury, please come down. You don't see that on TV. You don't see that ever talked about. But one of our founding fathers, Thomas Jefferson, stated that a sit on a jury of your peer was more important than the right to vote. So just let that soak in a little bit of where you're at right now, of what this nation started as and where we have come so far. We still have that right to vote, which everybody talks about, but we also have that right to sit on a jury of your peer, which one of our founding fathers believed was more important than the right to vote. So that's where we're at in this process. And I hope that through this process, you're going to really learn something new and actually enjoy the process. If you're picked to be on this jury, I hope you feel that it's an honor, because the fact is you're being a part of the fabric of this nation, and you're part of that as a U.S. citizen. So that's where the importance comes from. And let me tell you, I don't use the overhead very often. Again, the MTV generation. So my younger cohort here, help me with this overhead. So I'll refer to this sometimes, and in front of you over here in the jury box, you have your own screens. Y'all guys just gonna have to look up here with me. This is what we're doing. Is this like, are you the best juror for this trial? Will you be fair and impartial? Anybody here feel that they will not be fair and impartial? All right. And we're looking for, will you follow the law? A very hard scenario that the judge just gave about the range of punishment. Talked about a spouse that was dying and you pull the plug in a sense. You know that you're intentionally and knowingly, buzzwords, intentionally or knowingly pulled that plug, right? You murdered that person. They weren't dying yet. They were maybe gonna die, but they did not. That's considered a murder. If you say right now that you're gonna follow the law, I mean, there's a lot of other moving parts to that, but if we present the elements and we prove that, that means you follow the law and that person is guilty of murder. Does everybody understand that?
Yes.
Yes.
Does everybody agree with that?
Yes.
Judge already went over this, jury selection. This is the jury selection process. There's a bifurcated system in the state of Texas, which most states have. The guilt, which the judge likes to say guilty or not guilty phase. You as a jury get to determine that. And you determine after the end of our jury selection, the presentment of evidence, and then when we actually give you a jury charge, which definitions and everything are in that jury charge in the law, you will get that a packet and you will go back to the back room and the 12 of you, as the 12 jurors that are selected, will actually deliberate and determine guilty or not guilty. Okay, that's the first portion. Now, the second portion, obviously, if it's not guilty, you don't get to the second portion. But if it's a guilty, it goes to the second portion, which is punishment, which I usually talk about at the end, but since we've talked about it already, I think we already sort of went through that system right now. You go to that, you determine there's no probation for murder in the state of Texas. They do have parole, they do have things for like, if you get 5 years, you get 10 years, you get 15 years, you get 20 years, 30 years, 40, 50, 60, 70, 80, all the way up to 99 years or life. Only difference between 99 years and life is that if you live for a very long time past that 99-year mark, you're still going to be on parole. Okay, that's the difference. Everybody asks that. What's the difference between 99 and life? 99, at one point, if you live that long, you'll be off parole. Okay, that's the only difference. And saying that, does everybody agree that they can follow the law and consider the full range of punishment? Anybody out there that say, hey, no, I could never sentence somebody to life or below? Number 23, if you don't mind, can you stand up and just tell me you cannot follow the law?
I can't determine somebody's punishment. It's not my law. It's not my right to determine.
Okay, is that religious reasons? Okay, I think we had that earlier. Thank you, sir. Number 13, yes.
I need to follow the law.
I'm sorry, could you speak up?
Yes, because she has to get everything
Oh,
down.
I'm
Okay.
sorry.
Yeah.
Maybe I can follow the law, but I don't feel at all comfortable knowing that maybe I'm gonna send someone, to that punishment at all.
You're nervous about it? I can see that you're sort of
Yes.
getting emotional right now,
Yes.
just anxious and nervous about it. Is that right?
Exactly. Because I don't feel comfortable at all. I don't feel that I could decide someone's future in this matter at all. I've
Okay.
served before in the church, like 6 years ago, and I was able to do it, but it was a civil thing, the street was different. Just about when I just came here, saw the word murdered, I just started panicking, to be honest.
Okay. Thank you very much for sharing that. And I'll tell you this, remember this, this is not a death capital, which is a capital death case. Death, sentencing the person to death is not on the table. I know that it's not what you addressed, but I want to make sure to make that abundantly clear. The death penalty is not on the table and death, so just to let y'all know. And I saw another card raised. Anybody else? No? Okay, thank you. On to the elements of the case of murder. You'll see that it says paragraph A. There's 2 paragraphs. And what I'll tell you about that, if say 6 of the jurors say paragraph A and 6 jurors say paragraph B for guilty, that's unanimous and it has to be unanimous. All 12 jurors have to agree that's murder, okay? But the way you get there, 6 of you can say paragraph A and 6 of you can say paragraph B. It's under the same count. Y'all come back together as 6 and 6, and that's unanimous verdict of guilty for murder. The elements that we have to prove beyond a reasonable doubt, which the judge mentioned, there's no definition for beyond a reasonable doubt. It comes to your common sense, because in the end, it's your common sense. Okay, don't leave that at the door. Don't leave it at the step of the courthouse. Use your common sense, your reasonableness here. We have to prove the date. We have to prove that happened in Bexar County, Texas. We have to prove the defendant, who that person is, intentionally or knowingly. I'll give you a definition of that. And at the end of the trial, you also get definitions. So you do not have to memorize anything I say. Causes the death of the victim by shooting, stabbing, or some other type of way of killing someone with a deadly weapon. That's paragraph A. That's what we have to prove beyond a reasonable doubt. Okay, those are elements that we have to prove. If I come in here or Daniel comes in here, we put up evidence and we put up everything we have, and then we say we rest and we move to close, and I didn't prove the date, I want the 12 of you to go back in that jury room and say not guilty of murder because you did not prove the date that it happened, or that I didn't prove Bexar County, Texas. How we prove that is we're going to be getting to that in a second, but very simple. Somebody gets up here and testifies, hey, it happened in Bexar County, Texas. It happened on this date. That's how we prove. The evidence comes in through that stand up there. Okay, that's the first paragraph, or the paragraph A rather. Paragraph B, same thing, pretty much, but it's the date, the county, the defendant, intent to cause serious bodily injury. That's what SBI stands for. I'll give you a definition of that also. Defendant commits an act clearly dangerous to human life that causes the death of the victim with a deadly weapon. That's paragraph B. Intent to cause SBI, serious bodily injury. Can anybody give me an example? If I'm, if I'm just intending to cause you to like serious bodily injury by shooting you. Let's see, number 4. What do you believe that would, what does that mean to you?
What, the SBI?
Serious bodily injury.
Serious bodily?
Serious bodily injury.
Anything that like affects, I don't know, like their quality of life.
Right.
their
It's very,
ability to
very
live.
broad.
Yeah.
But I mean, if I come up and I go, hey, I'm going to shoot you just in the leg because I want you to fall down. Is that the intent to cause serious bodily injury? Am I causing serious bodily injury to you by shooting you?
Yeah.
Right. And could that cause your death?
Potentially.
Yeah, potentially, because that's an act clearly dangerous to human life, right? And believe it or not, people get shot in the leg a lot and they die from that shot in the leg. So that is an act clearly dangerous to human life, right? So keep that in mind. Those are the 2 paragraphs, okay? I'll jump into the definition of serious bodily injury. Y'all can read it. I don't know if I have terrible eyesight, so I'll read it out to you. Serious bodily injury, which is SBI, means bodily injury that causes substantial risk of death or that causes death, serious permanent disfigurement or protracted loss or impairment of a function of any bodily member or organ. You don't have to memorize it. It'll be in the jury charge later on, okay? But what that means is it's that, again, if I say I'm just going to wing that person and stop them from running at me or running away from me or something, and I just gonna just shoot them in the butt or something like that, and all of a sudden causes the death, that's considered paragraph B, that's considered a murder. Okay. Now onward to a couple of the definitions. I'll go over sort of quickly. Again, you'll have definitions of these later. Intentionally is or with intent with respect to the nature of his conduct, or 2 as a result of his conduct when it is constant, objective, or desire to engage in the conduct or cause a result. I just read through that so quickly. I mean, I was like, really, in all honesty, it's a lot of legalese almost. It pretty much means if I get a gun out and I point at you and I shoot, I'm intending to shoot you. That's you're intentional, okay? Knowingly is very close to that. I'm going to skip over the first part of that definition. I'm going to read the last line. It says a person acts knowingly.
Oh, Jason.
Jason, read slowly, please.
A person acts knowingly or with knowledge with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause a result. It goes really to that direction of like, if I shoot into a crowd of people, I knowingly shot into this crowd of people. I knew those were people. Maybe I didn't intentionally aim at number 2, juror number two. But I hit number two, okay? Knowingly shooting into that, that means that you're knowingly doing it, okay? It's not that conscious, it's not like the first one, conscious objective or desire, but it's reasonably certain the cause of the result. Okay, does everybody understand that? I know I'm going over definitions right now, but that's how we do it. Now, how do we prove intent? One, words and actions. Okay, words and actions. Somebody speaking, somebody saying. That's how we prove it. And also your action. If I'm walking across, I'm walking towards this wall, I'm walking towards this wall. That's my intention, right? Now, one of the things is that I didn't mention earlier is motive. Did anybody see that in the elements? Like, there's a little section for motive. Tell me this, why can't we prove motive a lot of the times? Number 5. Why do you think we can't prove motive?
Subjective.
Objective?
It's subjective.
Subjective, right. I always used to get those objective and subjective until like I was like in high school. I didn't really know which ones were. But okay, so the fact is, you're right, it's subjective. It's in your mind, right? It's your motive. And how do we can't, you should open up somebody's mind and say, hey, we're going to get that out of there, right? So a lot of times we can't prove motive. Now, if we can't prove motive, you may never know why a murder happened, right? May never know. It might be because an ex-lover, it could be a drug deal, it could be that person slighted me before and I decided to get him back. I mean, there's a million different motives that could be out there, right? So does anybody here say, hey, I have to hear motive. I want to hear motive. And if I don't get motive, I'm not going to be able to get to the end and decide guilty or not guilty. Anybody? Burden of proof, like the judge said, is on the state. It never shifts to the defense ever. It will never be on this table ever. It is our burden, beyond a reasonable doubt. We have to prove beyond a reasonable doubt that the defendant is guilty. If we don't do our job as the state prosecutors, you come back in here and you say not guilty, you didn't do your job. That's what I want you to do. And so again, the burden is on us. I'll hit on this again. The defendant can choose not to testify, or rather they don't have to testify. That can't be used against them. That's what the judge said earlier. Again, beyond reasonable doubt, it's not beyond all possible doubt or a shadow of a doubt. It's beyond reasonable doubt. Like I stated earlier, use your common sense. It's not rocket science here. And I hate using that word because, I don't even know what a rocket science does. But the fact is, it's not very complicated. Use your own common sense. Don't leave that common sense on the steps of the courthouse when you walk in. I'm going to ask you this question. And, before I sort of asked that question, but I want to get some details from you. And I'm going to ask you to raise your card when I'm going to do it by sections. I'll do it by this section up here, and then this section, and then that section, in 3 different sections, okay? I'm going to ask you this question. I'll read it out to you. It says, if you believe all elements beyond a reasonable doubt, would you be able to find the defendant guilty even without knowing the motive? I'm going to say number 5, as you strongly agree with that, or 4, you somewhat agree. 3, you don't know, or you have no opinion and you don't care. Number 2, you somewhat disagree, or number 1, you strongly disagree. Does everybody understand the question? Any questions on the question? No? All right. So in this section up here, 1 through 14, I'm going to ask you, I'm going to say, out of all y'all, raise your card if you agree with number 5. Okay, you just hold them up, keep them up, please. And I'm going to go through here, number 5, 9, 11, and 12. Thank you. You can put your card down. Who agrees with number 4? Number 1, 2, 4, 6, 7, 10, 13, and 14. Thank you. Number 3, agree with number 3. Number 3 agrees with number 3. Sorry about that. All right. Number 2, agree with number 2. Number 8 and number 1. Does anybody agree with number 1? Okay. Thank you all very much. Now this is the big section over here. All right. Let's go with who agrees with number 5. Raise your card. And as soon as I call out your number, you can put your number down. 25, 29, 34, 39, 40, 49, 45, 46, and 56. Thank y'all. Who agrees with number number 4? Someone agree, 4. Number 15, 16, 17, 19, 20, 21, 24, 26, 27, 28, and 30, 33, 35, 37, 38, 42. And I'm sorry, I missed 36, 48, 50, and 55. Did I not say this? 21. Sorry about that. Agree with it. Number 3. Anybody agree with number 3? Number 23, 31, 41, 43, 44, 52, and 53. Thank you. Agree with number 2? All right. Number 22, 32, 47, 51, and 54. Thank you, sir. And agree with number 1. Anybody agree with number 1? Okay, thank you. Over here, everybody understand the question? All right, I'm going to try to go quick. Agree with number 5. We got 63, 66, 67, 73. Agree with number 4. 57, 60, 62, 64, 68, 70, 71, 72, 74, and 75. Agree with number 3. Number 58, 59, 61, 65, and 69. And agree with number 2 or number 1. Okay, there you go. All right. Onward. How to prove the offense? This is where we get to physical evidence and witness testimony, right? There's 2 ways, there's many ways to prove up. But the fact is physical evidence. Let's talk about physical evidence. Well, I'm going to ask questions here. Number 21, what do you believe some physical evidence that would come in?
Something videoed.
Yeah, video.
Photos, somebody, a weapon of some sort would be physical evidence.
Well, I mean, you hit the gambit. You hit a lot of it. Yeah. So exactly right. That's physical evidence, right? And that physical evidence is what I like to call a part of the puzzle pieces, right? That there's puzzle pieces that come in. There's maybe a weapon, right? And maybe a video. Like what type of videos could possibly be out there?
Security footage.
Security
or
footage?
Somebody filming with their phone.
So wait, everybody has cell phones now, right? And sometimes it'll be on a cell phone. You see it on the internet all the time or something like that, where they see an accident happen or something, and it's sometimes on surveillance videos a lot of times, and sometimes it's on a cell phone, and sometimes it just it comes from the regular cameras and everything. So that's right. There's a bunch of different type of evidence that's out there. Now let's go to witnesses. Number 19. What do you feel that some of the witnesses that would be coming in for a trial like on murder? No problem. But what type of witnesses do you think would be coming in?
Like someone that saw.
Somebody like an eyewitness, right? That's always a plus, right? Does everybody believe that eyewitnesses always get it right?
No.
What?
No.
I mean, eyewitnesses don't always get it right, right? I mean, I think history proves that. I mean, the fact is that in my history of dealing with eyewitnesses, they don't always get it right. So who do you think judges their credibility, whether they got it right or not? Who does that?
Jury.
Exactly right. The jury gets to determine it, right? They get to sit up here and determine whether it's they judge their credibility, really. That you're the judges. It's not the judge is more like a referee. She's going to tell us yay or nay, whether objection is overruled or sustained. And that's where it comes from, that the jury is really the judges of the credibility of the witnesses that come in, and also the evidence that comes in. That evidence of videos or weapons that come in, you get to determine that. And so there's certain eyewitnesses that would be coming in. What other type of witnesses might be coming in? Well, officers, right? You got CSI, which is crime scene investigations. You got possibly medical examiners. I mean, this is a murder. We're gonna have a medical examiner come in and discuss about the person that died. What other type of a witness would possibly come up on that stand? I'm sorry? And I'm sorry, what number were you? Number 12. Character witnesses? Sometimes they can come in sometimes. I mean, if that is raised, a lot of times that would fall into more the punishment range or in the punishment phase. Because I'll tell you this, one thing you won't be hearing about a lot of times is if, like say, priors, like, a prior conviction or the person has history. I mean, for instance, for the defendant, you won't be hearing about that because that could make you biased against him or her for that matter. So keep that in mind that you will not be hearing about that. Now, if a witness gets on the stand that they have history, you will hear about that because that goes to what? Their credibility, right? Because you can judge the credibility by that sometimes. If somebody has a felony, does anybody here say, if you have a felony conviction of anything, I'm never going to believe you. Whatever you say is a lie because you were convicted of a felony rather. Anybody? Does everybody agree that you're going to judge their credibility when they're on the stand? Does everybody agree with that? Okay. Why do you think a witness would not come in? Number 60. Why do you think a witness would not come in? Yeah, would not.
All right, so the rules,
Oh,
a
yeah,
reporter
sorry.
has to hear.
They feel uncomfortable.
Okay, you hit on it. Sort of felt uncomfortable. Why would they feel uncomfortable?
Providing a testimony.
Okay, well, thank you. You can say that. Well, I'll tell you the number one thing that a witness always says to me. Oh, I'll tell you everything you need to know. I'm not going to come testify. Well, what? You just told me what you saw. You're an eyewitness. You saw everything that happened. You got to come in. Why do you think they don't want to come in? Number 7.
Retaliation.
Retaliation. That's a problem, right? Because people are scared of what? Retaliation. And what would retaliation mean? Something bad happens to them or their family, right? People don't want to get involved. Remember that. That's one reason for missing witnesses. It's a big reason. That's the number one reason that I'm told every time. Now, does it happen? Rarely, yes. Does it happen? Yes. But it's not really a huge concern because that doesn't happen as often as people think, because everybody watches CSI, everybody watches those TV shows, which is anybody here think that everything that happens on TV is pretty much accurate that happens on CSI, Law and Order? Anybody? Please raise your hand. Please raise your hand if that's the case. I'm not gonna make fun of you. I'm just gonna say this. Wait. All right. Well, the judge will tell you that. But, all right. Let me tell you this, that remember this, whatever attorneys say, myself, Daniel included, Mr. Cox included, any attorney, that's not evidence. If I ask you a question, or if I'm asking a question, that's not evidence. Just because the question's asked doesn't mean that it is an actual piece of evidence. Whatever the answer is evidence, but not what the question is. Keep that in mind, because questions can be formed, and you're like, ah, there it is. But the question is just a question. It is not evidence. Also, remember this. I get this at the end of almost every trial that we've done. The jury goes back to deliberate, and then they send back, we want to see the police reports. Police reports are not evidence. They're used to, the officer can read, in a sense, remember the actual, thank you, the event because you wrote it down, say a year ago or 2 years ago. So the fact is, it helped to remember the actual incident, and so it's not evidence. You will not be able to read police reports unless they're entered into evidence, and it's very rare in a criminal case that it's entered into evidence. Now, let's go on to the Fifth Amendment. I'm going to touch on that briefly, but everybody agreed that the right to remain silent is a right that we all are afforded. And there's certain reasons why you won't want to testify. There's certain reasons you would want to testify. Does anybody here say, hey, up here in this section, if I was accused of a crime and I didn't do it, I'm getting up on the stand and I'm going to tell everybody I didn't do it. And there's nobody stopping me, including my attorney or anybody else, because if I didn't do it, I'm getting on the stand. Anybody feel that way? You feel that way, right? But the fact is, sometimes it's not a good idea. I've been doing this for about 18 years. Y'all been doing it for a few hours, right? I mean, I think that if I cross somebody and they just stutter a little bit, or they start sweating. I mean, sometimes when I get embarrassed, my ears turn red. I'm bald. You're gonna see my ears, right? So the fact is, there's a million different reasons why you might not want to testify, because even though you're innocent, you might look guilty. And everybody knows that, right? You judge a person's character sometimes and their credibility by looking at them, and they start sweating, they start stuttering, if they're talking really fast, or they're talking really slow, or they're avoiding a question, or they're thinking about a question. Millions of different reasons why, right? So would everybody here agree that, hey, if they take the stand or they don't take the stand, I won't use that against them or not against them or for them? I mean, because you can't give them brownie points for just taking a stand, right? Just because you take a stand doesn't mean, hey, guilty person can take a stand and probably do a better job on the stand than an innocent person, tell you the truth. So does everybody agree that they're not going to be using that against them? Everybody? Yes. Okay, thank you. Okay, onward to, let's talk about, oh, there you go. Have you or someone you know been accused of a violent crime? And I'll go over here, this section. Anybody that you know or a family member or yourself been accused of a violent crime? Anybody up here? Just raise your card. Okay, and I'll go to number 2. And can you just expand on that? If you feel comfortable, of course.
It's a friend who got charged with manslaughter, driving intoxicated.
So intoxication, manslaughter, and was that person prosecuted? And you feel like they were treated fairly during the process?
Yeah.
Okay,
I'm sorry? Yes.
and you feel that even knowing that or being a part, just a friend of yours, do you feel you still be fair and impartial in a jury trial like this?
Yes, sir.
Okay, thank you. Number 6. You just gotta speak up because the yes,
My brother-in-law was accused of sexually abusing his grandkids and he beat on them.
and what?
And he beat them up,
He beat up the
the grandkids.
grandkids. So he was charged with that. Was he convicted of that?
Yes.
And do you feel like he was treated fairly by the system?
Yes, because he was good.
He was guilty. And so just knowing that type of case and knowing what type of case this is, which is obviously different. But the fact is, do you feel that you can still be fair and impartial? Well, unfortunately, it's one of those questions. It's like, are you pregnant or you're not pregnant?
Yeah.
It's not like, yeah. It's like yes or no.
I couldn't tell you a yes or no.
All right, so
I
you
don't even know what, you know.
okay,
this person.
okay. Thank you, ma'am. Number 7?
I know someone who was accused of assault.
Assault. And were they convicted or you said accused? So were they convicted? Okay. Oh, I'm sorry, it's pending?
Yes.
Okay. Do you feel, knowing about that situation and what the type of case this is, do you feel that you can still be fair and impartial on this jury trial?
Yes.
Okay, thank you. Anybody on the top row? No? Okay, this front row? Second row? Number 24. If you don't mind standing up. Just project your voice.
You mean human trafficking?
Human trafficking.
Only
And
because where the person worked and he was the only person that still worked there at the time because everybody else had left. He was brought in for that charge,
okay,
which was dismissed, but it was very upsetting. And you know, when you're looking for work after, because this was during COVID and everything, and it's just pending.
Mhm.
And even though you're presumed innocent, even people still presume that you're guilty. And when you go try to look for jobs, it's, oh, you have a case open, but we can't hire you because you have this, but yet you're not accused of anything. And it was upsetting.
okay. And but knowing that, I mean, obviously, I mean, it feels like to me, tell me if I'm wrong, you feel like he was treated unfairly because he was just accused of it.
He was just
Okay.
accused of it. It was dismissed, but
It just-
yeah,
Okay. And do you feel that you can still be fair and impartial in a jury trial like this?
I think so, yes.
Okay, thank you, ma'am. That after this first row, second row, third row, number 32. If you don't mind standing up, sir.
I shot 2 dogs with my neighbors after they rushed me.
You shot
My neighbor's dogs.
neighbor's dogs.
Yes.
Okay, I was like, I might want to clarify. And so you shot your neighbor's dogs. Were you charged with something?
No.
Okay, and the police came out?
Yes, sir.
Okay, and knowing that situation that happened, and do you still feel you can be fair and impartial in a trial like this?
Yes, sir.
Okay, thank you very much for sharing, sir. Anybody in that row now? And then the next row, fourth row? And the fifth row? Okay, last row, 51? I'm sorry, you just gotta speak up.
Close family member,
A close family member assaulted a police officer, and were they, is it still pending, or is it they? Okay, and do you feel like they were treated fairly during that process? Not necessarily,
no.
okay, knowing the thing that you feel now, knowing about that, do you feel you could be fair and impartial in a jury trial like this, to both sides?
No.
No, okay, thank you very much, sir. Number 55.
I'm sorry, ma'am, I can't hear you. Can you please speak up?
She said she has a friend of hers that committed,
Vehicular manslaughter,
okay,
but the charges were.
okay. And you feel that, knowing that, do you feel that you can still be fair and impartial in a trial like this?
No.
Thank you. Anybody over here? Starting in the first row, second row, 64?
My son was accused of sexual assault. It was acquitted of all charges, but I don't feel I could be fair.
Okay.
Side with defense.
Side with the defense. Thank you very much, sir. I appreciate it. Number 65.
Friend of mine was charged with manslaughter. I didn't know time. Afterwards, time.
Oh, I'm sorry, excuse me. All right, so everyone, the court reporter cannot hear. So speak as though you're speaking outside or your child has done something and you're trying to get their attention. All right,
I might get into manslaughter. I never asked the details. But he served his time and he's fully functional in society.
Okay. And do you feel you can still be fair and impartial in this type of jury trial?
Yes.
Thank you, sir. Number 75,
My cousin was part of the murder.
charged with murder, and were they convicted of murder?
Yes.
And knowing what you know about that case, do you feel you can be fair and impartial in a jury trial like this? Okay, thank you, ma'am. Number 73,
Had a friend in college committed, manslaughter.
and do you feel that you can be still fair and impartial in a jury trial like this?
Yes, sir.
Thank you. All right. Onward to, it's sort of the opposite question, but it took a lot of time, and I don't have a lot of time. So does anybody in general have somebody that was a victim of a violent crime, like for instance, a murder or an ag robbery or something of that nature? Anybody feel that if they have a friend or a family member or themselves for that matter, that was a victim? Of course, you're not a victim of murder, but the fact is of an ag robbery or ag assault or something like that. Is anybody up here? Anybody, number 14? Do you still feel that you can be fair and impartial?
Yes.
Okay. Over here? 22.
My brother's house was broken into.
Mhm.
There was assault. They were okay, but
Okay.
there was robbery,
As a robbery, so a home invasion. type
home
thing.
invasion. exactly.
Okay. And do you still feel you'd be fair and impartial?
No.
No? Okay, thank you. 30?
Yes, my grandmother experienced a home invasion. I don't think
okay, you're whispering. I can't hear what you're saying.
Grandmother experienced a home invasion, and I do not think that could be impartial.
Okay, thank you. Number 33?
A coworker was a victim of aggravated sexual assault.
Okay, partial. Thank you. Number 47?
Personal reason, when I was younger, I was severely beaten by my older sibling.
Mhm. Well, that, you gotta remember that this is not that type of case. This is a murder. This is not a sibling murder. What's that?
It was violent.
It was violent. Okay, the violence. Okay,
Yeah, I had to go to the hospital. I had broken bones.
Okay.
facial-
I'm sorry to hear that happen, ma'am. Thank you very much.
All right, and just one moment. So everyone, when they're talking about whether or not you can be fair and impartial, everybody has experiences in their life that maybe have been horrible experiences or bad experiences. The question is whether or not, if you were selected on this jury, that you could base your decision on whether somebody's guilty or not guilty, if you can come to the decision, based upon what you hear in the courtroom, not based upon what happened to you. Does everyone understand?
Yes.
So those people who are asking those questions, that's the question. whether or not, if you're on the jury, you can listen to any evidence that's brought to you and base your decision on whether somebody's guilty or not guilty based upon the evidence you hear, not based upon what has happened to you or maybe what has happened to a loved one. Does everyone understand?
Yes.
All right, you may continue.
Thank you, Judge. I think Judge sort of, again, I have limited time. I'm coming up on the last part there, so I think she cleared that up. So we're gonna sort of speed through some of this portion here. And I'm gonna go ahead and jump to the justifications or defensive. One thing that could be used in a murder case is self-defense, right? Everybody agrees with self-defense. And the definition of the state and the state of Texas of self-defense is Penal Code number 9.31. The definition is the person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. I highlighted the portions. Reasonably believes that is immediately necessary. Okay. The definition of reasonable belief means a belief that would be held by an ordinary and prudent man in the same circumstances as the actor. That's the definition. You will get that definition later. But the fact is, that's the definition. What I tell you is the bottom phrase there, common sense. That's a common thing. Use your common sense. Okay. Let's talk about that self-defense. Reasonable reaction, right? You use equal force. If I come up and I pinch Daniel, do you think it's okay for him to grab that laptop and slap it across my face? Is that equal force? You see how that would be overreaction, escalation of force? If I act like I'm going to pinch Daniel, which is like the attempted force, right? But then he punches me in the face, is that an escalation of force? You see how that works? Immediately necessary. I'm standing over here. I tell Daniel, I'm going to punch you. He throws a rock at my face and busts my nose. Is that immediately necessary? If I'm telling him I'm standing here, I'm going to pinch you. Does everybody understand that and agree with that? If I tell him I'm going to pinch him, but then I walk away and he throws a rock at my head, is that immediately necessary?
No.
And not only not immediately necessary, but also escalation of force, right? But I tell him I'm going to pinch him. That's words alone, right? That's not self-defense. It's common sense, right? Does everybody agree with that? Also, you cannot provoke the difficulty, meaning I keep on antagonizing. Remember this, you must also admit it to get it. You must say, I'm the one that stabbed him. I'm the one that shot him. I'm the one that did that to that person that is dead because I did that. When can you use deadly force? Deadly force is a person is justified in using deadly force against another. Everything that we just said before. And when and to the degree the actor reasonably believes, there's that phrase again, that if deadly force is immediately necessary. Again, not only did the state legislature put it in the first part, they actually reiterated it in the deadly force statute or penal code statute. The fact is that reasonably believes and immediately necessary are two factors that cannot be separated. They're said twice just to get deadly force that you can use it. Let's talk about that a little bit. I brought up the fact about a rock, which could be a deadly
5
weapon,
minutes.
right? A gun is a deadly weapon. A knife can be a deadly weapon. Gun per se is a deadly weapon. Let's talk about this. Let's say I get a knife and I'm walking towards Daniel. And then I start jogging towards Daniel and I have that knife and I'm not even saying anything. I'm just raising it. I'm coming towards him. I'm going to stab him. My intention is to stab him. That's what I believe. He has a gun on him. What can he do? Number
26.
26. What can he do?
He can defend himself with equal or more force to stop the threat.
To stop the threat.
Yep.
So I'm coming at him. He can raise that gun and shoot me.
Yep.
Right? Does everybody agree with that?
Yeah.
Anybody disagree with that? What about this? What if I have that knife? I'm coming towards Daniel. I drop it. I look at him, I go, oh God, and I run out the door. And he raises the gun and shoots me. Does anybody in here say that that's okay? That's self-defense still? What about before I leave? I go, I'll be back. Does anybody say that's okay to shoot him? Number 64, you say it's okay?
Yes, because he could be going to his car to get a gun.
Okay, but what if there's no car? What if I'm just running? Say I'm like 20 feet away, 30 feet away, and then 40 feet away.
I still don't know if he has a gun or out in the planter or something else.
Okay.
The fact that you said you're coming back. Is a threat.
Okay. Anybody else agree with that?
Yeah.
Okay, number 34. 34. Number 52, 53, 19,
Oh, no.
51, 56. Anybody over here? Number 1 and number 11. Okay. Remember this, just to reiterate. It can't be a future threat. I can't say I'm gonna come back. Is that immediate? Is it immediately necessary? Huh? I can tell you all day, how many times have somebody said, I'm gonna kill you? I'm gonna kill you. Not everybody said that, I agree. But as a kid, you said it. I'm gonna kill you. I'm gonna get you one day. So that's a future threat, possibly, a future threat. It's not immediately necessary. Words alone cannot provoke. Mind you, if you do provoke, say you do have that knife and you say, hey, I'm gonna get you. Put the knife down and you go, okay, I'm gonna leave this alone. I'm done. I'm out of here. You abandoned the situation, right? Is it okay to shoot the person? Anybody agree with that? Anybody say, hey, you could shoot him? All right. Remember, this is the last resort to use deadly force.
1 minute.
Thank you, Judge. Last resort. Use your common sense. This is going to be very quick. Self-defense must be immediately necessary, not a future harm. I'm going to ask you, number 5 is strongly agree, all the way down to strongly disagree. Who agrees with number 5? 1, 2, 4, 6, 7, 8, 10, 12, and 13. Agree with number 4, 5, 3, 9, and 14. And then also number 3, 2, and 1. 3 is number 11. Right over here, first row. Number 5, 16, 20, 24, 25, 26, 27, 33, 32, 39. I think everybody's over here. Tell me this. I'll start from the bottom. Who agrees with number 1? Who agrees with number 2? Number 22, 51, 19, and 53. Who agrees with number 2? Okay, over here on the bottom. Who agrees with number 1? Number 60, thank you. And who agrees with number 2? 64, thank you, sir. And then agree number 3, 58, 65, and 70. The other ones are strongly agree or agree. Okay, thank you.
Time.
All right, thank you, guys. I appreciate it. Ran out of time. Mr. Cox will be speaking to you next.
All right, ladies and gentlemen, I'm going to give you all a 15-minute break. So what that means is everyone needs to be ready to go at 12:16. So look to your left, look to your right. That's your jury buddy. Make sure that they are in line. So we're going to take a break and you'll be back lined up outside at 12:16. If you're looking for a restroom, find the stairwell. On the stairwell, wherever you go, there's a restroom on the left and the right. So if you see the restroom is crowded on this floor, if you go down to the 3rd floor to the stairwell, restrooms are there all the way down to the 1st floor. Does everyone understand?
Yes.
So please leave your cards behind and don't come in the courtroom. Just line up outside. Everyone, please rise. Oh, you all may start leaving.
Oh,
And if you want to leave your items behind, you can. No one's going to touch them.
Yes.
No, you all, please be seated. We stand for you. All right, everyone, please be seated. Mr. Cox, are you prepared to proceed?
Yes.
All right, you may proceed.
Thank you. Good afternoon, everyone.
Good afternoon.
Excuse me, number 39.
We're missing a juror,
All right, just thank you for letting us know that. Which juror number are we missing?
41.
And 12.
Well,
All right, so we're just gonna sit here and enjoy each other's company while we wait on number 12 and 41.
Your Honor,
Yes,
if I may.
and your number is 32?
Yes, Your Honor.
Yes.
I have an appointment next week, Tuesday. I failed to mention that earlier.
All right. And 32, when is your appointment?
The 19th, I believe, on Tuesday
And what time is your appointment?
at 9:30.
All right, thank you.
Your Honor. Yeah, earlier when we were talking about travel, I didn't know if we were talking about medical stuff as well.
Mhm.
I was confused why people were talking about that, but I do have 3 appointments on Tuesday. This coming Tuesday,
Okay,
dentist and eye appointments.
all right. Is that a dentist and eye appointment for yourself?
Yes,
All right, and what time?
8, 9, and then the 10,
And what date?
Tuesday. This coming Tuesday.
Right.
The 19th.
All right, thank you. Deputy Laura, could you make sure they make an announcement for that juror?
Yes, Your Honor, he's not on this floor.
All right, thank you. All right, could I see state and defense? All right, Mr. Cox, you may proceed.
Thank you.
And just so the ladies and gentlemen are aware, with regards to that juror who is not here, Mr. Cox will be allowed to get a chance to speak to that juror once we find him, but he's okay with proceeding now. All right, Mr. Cox.
All right, thank you. Again, good afternoon. I'm gonna try to keep my voice up, so one's in the back here. I know there's one over here, and I'm gonna try to move around a little bit, so hopefully, everyone can hear me. If there comes a time when you have difficulty, just kind of wave to me in the back, so I'll know to speak up and to say loud. Okay. Now, jury selection. It's always been the most important part of the trial. Sometimes, some people think about, well, you're gonna play like basketball, football, or volleyball, or something like that. And the coach spends a lot of time in practice before you ever play a game. Sometimes we thought, oh, the practice is boring, and sometimes you want to get to the nitty gritty and what's going on. But the selection process, in my opinion, is actually the most important part of the trial. And the reason for that is that this is the only time as a juror that you'll have an opportunity to talk directly to the lawyers. Because what we try to do, we try to determine which ones of you would probably be, not necessarily most, but the ones that would be a proper juror for this case. Sometimes just the nature of a case. And in this case, specifically, we're talking about we're going to try a murder case. You may not feel that you're a proper person to sit on judgment or make the decision. You need to realize that any answer that you have, that you give us, or any question that you ask is an important question. Because what we don't want to have happen is for someone to be seated on the bench and that person has reservations in terms of whether you can base your verdict on the evidence presented in court. Whether it's a situation where you have something that may have happened to you that makes it impossible or makes it extremely difficult to you to be fair and impartial. Because once you're seated, then it's kind of too late. There's not a lot you can do to try to resolve the issue. That's why we take the time asking all these questions. That's why we take the time kind of going into the background just to make sure that at the end of the day, you're selected to serve, that you can be fair and impartial. There's no right or wrong answers. You don't have to be politically correct. If you feel a certain way, you have a strong belief about it, you're not going to hurt our feelings by telling us. We just want to kind of get to the basis of whether or not you can be fair and impartial. And if you can't, you gotta let us know. It's always put it, it's kind of like wedding ceremony when the other preacher says, speak now or forever hold your peace. No reservation. So with that, we need to know, like I said, no right or wrong. Don't feel that, well, if your position is that I cannot put certain things aside and make a decision. You just gotta listen. Now, if you're selected as a juror, then part of your job is to decide the facts of the case from the evidence presented. So, and like the prosecutor mentioned that what the lawyers say, what we say is not the evidence. The evidence will come from the witness stand, or there's sometimes documentary evidence, exhibits for you to consider, and that's basically the evidence. You're to judge the believability, credibility of witnesses. And you can believe all of what a witness says, or part of what a witness says. Another thing that's very important is that your vote is critical. Most times, and when we deal with our local systems, we people are on democracy where you have one person, one vote, and the majority kind of win. Unless we're talking about electoral college, so that's a whole different deal. The electoral college, that's a whole different situation. Now, if you're elected or you're selected rather to be in Missouri, then it's you'll have a vote, just like anybody else. It's notwithstanding whether you're a doctor or even if you were a actual judge sitting on the jury, your vote is just as important as anybody else's vote. Because what happens is that you become one of 12 judges of the factions. And that's why when you come into the courtroom, we stand for you. And you're not even judges yet, but we show that type of respect for you. You become one of 12 judges. That's very important. Why? Because if it's Friday evening, you heard all the evidence in this case, and you're deliberating, and you have 11 people that are voting one way. I'm not saying which way, but you see the evidence different. Now you can deliberate with them, you can confer with them, but if you have a well-founded belief that your vote or your verdict should be different from the other 11, what do? Do you go along, get along. Because someone may have plans that Friday evening, do you surrender your belief just to go with the other left? That's important. And only you can determine it. Because your vote is just as important as anybody else's vote. And that's part of our jury system. Now, we have different levels in our judicial system of burden of proof. Basically, and I think the judge may have mentioned that in a civil trial, the issue is you're in a vehicle accident, somebody hit you from behind, and the issue is money damage. Then the proof is by ponderance of it. Well, if you can tilt the scale in your favor, just tilt, you prevail. We have a second tier. And the judge mentioned this too, is that if it's a civil case where you're a parent and the state comes and what they want to do, they want to terminate your parental rights. Then the burden of proof in that case is clear and convincing evidence. The highest level that we have proof beyond or evidence on a reasonable fact. Unfortunate about it is that we don't have a definition for it. We used to have a definition for it, but for lawyers and the people that make the decision, they couldn't agree, so we don't have a definition. It would be nice if it was a situation where one of my favorite movies, National Treasure. Love it. History major, love National. Nicholas Cage. Because eventually, before they get to the treasure, they look, they like something, some oil, and all of a sudden, the room where all this treasure is just lights up and you found. We don't have a situation where when you get to whether or not state proof the case beyond a reasonable doubt, then what happens is that the heavens open, lights come on, and you know that's not how it happens. What we do know is that there's no definition for it, but we know that like the prosecutor said, we're not proven, the burden is not to prove their case beyond what they call a shadow of doubt. Most of you are too young to have ever heard that expression. But pyramids back in the day, a shadow of a doubt. No. And they're not asked to prove the case beyond all doubt. Because if that was so, then instead of you being on the jury, be a witness. But the burden of proof has to be, in my opinion, I like to say we can't tell you exactly what it is, but I would suggest to you that it almost have to put you in a position where you're actually described to you with such clarity. It's not being there, but almost like being. Now, there was some talk, and I believe that the judge mentioned. That a person, any accused is presumed to be innocent. Unless the state proves their guilt beyond the reason. So, like the judge said, hey, if it was a situation where I was just sitting here doing absolutely nothing, doesn't excuse the state from meeting their burden. And if they do not meet that legal burden of proof beyond the reasonable, then your instruction by the judge, by the court, is going to be to find the accused not guilty. That's the law. It's not a contest where you say, well, these one side, they look better, they seem to be earnest, working. No, it's nothing to do with it. It's based on the evidence in the law. You can't, inside kind of want to help the state, push or get over the threshold. You can't do that either. They have to do it. And if they can't do it, then you have to, they can't get over the threshold beyond reasonable doubt. And the law says you must by your verdict. They not guilty. That's the law. And sometimes people feel, well, it's just too hard a burden for them. And if you feel that way, and like I said, you can feel whatever way that you feel. See, it's not a political correct answer, but we just need to know. We spoke about whether a person or the accused can elect not to testify or to give evidence in this case. Some people feel, when the prosecutor mentioned that or got into that area, feels that if I'm accused of something, then I should say something, or I have to say something, or some of you may feel that you may require, even in the back of your mind, I think that person, I think I want to hear, I need, before I can make a decision, I need to hear something. And I'm not telling you that if you feel that way, that you're wrong. One thing I'm saying is that if you feel that way, we need to know about it. And it's only you, when the prosecutor mentioned motive, and he said, oh, you can't open up somebody's head. No, that's true. Only you know how you think. So if any of you, and like I say, it's not a situation where you hurt my feelings or find feelings or lawyers that are with us. We just need to know. Do any of you feel that just based at this time on even what you know or what we talked about at this point, that you could not be fair, impartial, making a decision in this case, if you do not have an opportunity to hear from the accused. Any of you feel, just put your number. Oh. All right, now I'll say the numbers, I'll go through them to make sure the court reports. All right, so we see number 11. Number 22, you're kind of waving, but not, you're moving it. I don't know, number 20, right at 20, your number. Okay, I was just making sure you were. Number 23. Number 24. Number 34, number 51, number 59, number, sorry, I'm not 59, number 49, number 43, number 70, number 58, and number 61. Okay. Many of you feel that just based on the nature of the charge, which is a murder, that you just feel that just based on the nature of the charge, that you could not be fair and impartial in reaching a decision just based on the nature of the charge. Anybody feel that? Okay. 13, 14, number 23, number 31, 27, 34, 47, 48, 49, number 78, number 58. Now, if you're selected to serve, like I said, you become one of 12 judges of the fact. And you can't base your decision on suspicion, intuition, feelings, or guesswork. And that's important to highlight that, because sometimes we get feelings about it. And sometimes our feeling that our impression that we have kind of governs us. And it happens all the time. I remember when I was a kid, I did not like macaroni and cheese. Just didn't taste it. I just looked at it and I just liked it. It just like I eat it all the time, man. I didn't start liking it until other than high school. At lunch, cafeteria, we had good cooks in my high school, and tried it. I've eaten it ever since. I've been out of high school a long time. So sometimes our impression with it, or we have say biases about certain things. And I had a bias about macaroni change, but that's the way I feel. Now, to any of you, just based on what you know, at this point, have a and I'm not saying it's got to be a politically correct one, but you may have a bias about this case, or kind of a prejudgment of this case, even before you heard anything that may affect your ability to be fair and impartial. Just say a bias. It could be based on charge, could be, based on anything that's inside you that says, well, that's a vibe. Can't shake it. I just know that based on everything or something, I could not interfere in this case. Anybody feel that way Could I see it? Anyway. Okay. 47 and 49 and number 61. Now, there are persons that accused of crime have, certain rights with, one is right of confrontation. It means that if there's a witness that's gonna testify, reference, against a person that's accused, then the defense has an opportunity to cross-examine that witness. And even sometimes it could be tense, the cross-examination process. But if you're an attorney, there's some things, some questions that perhaps should be asked. Do you feel that, well, I just don't think that people should have to be cross-examined or anything like that in a trial. So I'm just trying to get, is there anything that like that may cause you any type of problem that you would expect to serve on a jury? Anybody? Read it. Now, do any of you feel that just based on the fact that a person is accused of a crime, say accused in terms of being indicted, do you feel that you have this belief that with the smoke here, there's fire? To be fair, because if that person was indicted, that person's brought here, then you tend to feel that, that person must have done something wrong. Must be guilty just because mere fact that person is here. Person has been indicted. Now, important question, and then I don't want you to feel that, in a room full of strangers, that somebody, if you're worrying about someone thinking less of you because you feel a certain way. No, that's not the issue. But do any of you feel that you would tend to just based on the fact that a person is charged, that you would tend to feel that person is guilty, even though you haven't even heard yet? Anybody? I'll be shocked. 61, number 7, anybody? Number 22, anybody? Anybody? Like I said, don't feel you're gonna hurt my feelings. But we just need to know, just to assure ourselves that we have those of you, if you're selected, that could thoroughly be fair or any party. Now, I think we've covered, and the question was asked once, does anybody have any religious, moral beliefs that will make it difficult for you to judge? And I think there was at least number 23, number 13. I just want to make sure that nobody else that didn't raise to number 43, anybody else that didn't raise them, they just could not, they could not judge. Number 58. Now.
Oh, yes. May I ask that you speak up if you have your back turned?
Okay, yes, ma'am. Sorry. Okay. In terms of the range of punishment, Mary case. And these judge said, 5 years, 99 to life. Any of you feel that you could not consider if there's a verdict of guilty, that you could not consider the full range? Now, what that kind of means, I see number 20 feet of his Carter. And what that kind of means is that say for instance, you could consider life for 99, but you just can't consider a 5 year. So we're talking about the full range, whether you consider the low end or the high end or anything in the middle. Anyone feel that they could not consider for whatever reason the full range? All right, you can no. All right. Number 17, number 6, number 34, number 47, number 53, number 49, number 73, number 61, and number 58. Now, on the issue and Sept mentioned this issue of self-defense. And there were conversations about if, say, deadly force was used against you, or you feel that deadly force was used against you, was going to be used against you, for you to be able to use deadly force against that force. And is there anyone that feels that under no circumstances that even if someone was attempting to use deadly force against you, or the process of using deadly force, that you should not be able to use deadly force against the force that is being used against anybody here? I need to repeat that one. I remember when the prosecutor mentioned that, well, say he was running towards someone with a knife and he was say going to stab that person. I think everyone agreed that, well, if that was going to happen, you probably were going to be there. Could you use deadly force against the person coming against you to use deadly force? We anybody that disagree that, no, under no circumstance. I should take the vote, shouldn't use deadly. Anybody feel that? Any of you feel that in a case of self-defense like that, would you have to wait until the person actually stab you to use deadly force? If you can use deadly force, would you have to wait until you got to get stabbed to use it? Anybody feel that? No, I don't see any. Any of you believe that if, like we mentioned before, a person or anybody charged with a crime can elect not to testify. But say, for instance, a person who started the crime elects to testify, would you? How many of you feel that you would just automatically disregard that person's testimony because he's a person accused or she's a person accused? Anyone feel that, I just have to disregard that person, whatever that person says, because they're the one that charged the crime? Anyone feel that way? So I got a few. I'm sorry, we don't have the opportunity to learn everybody's name. But I may call some numbers out. That's why the numbers are important. So choose me in advance if I don't use the name on every question. But I'm going to ask some individual questions. And I think the first candidate on this one is number 10, right? Manuel. Yeah. Pena? Yes, sir. All right. Sure. Now, need to ask you a question. Don't wanna vote and say, but you work for Homeland Security? Yes, sir. All right. I don't want anybody to treat you different because you're working on Homeland Security, but is it anything about, you work with a lot of, well, you're part of law enforcement. Yes. Have you, before you went to Homeland Security, did you ever work anywhere in terms of law enforcement? No, the closest was the Marine Corps. Okay, Marine Corps. Now, is it anything about your job, which you do, that would make you will make it that you could not be feared and partial when you selected this job? Okay. But you rely on your job, you relied on police officers too, correct? Yes. Okay. Would you if a police officer say took the stand, would you they value the police officers testimony more than a regular civilian?
Value, I would say maybe a little bit more because I know the kind of work she does. I can relate to it, but not necessarily not taking into account everybody else's testimonies.
Okay. So you would consider, if fair to say, consider what that person actually said or testified to. Yes, correct. So in other words, would you believe the person's testimony is based solely on the fact that that person is a law enforcement officer?
If he took the stand and his testimony, I would believe, even if he's not a law enforcement, yes, I would believe his testimony.
Okay, so if the law enforcement officer, you're from San Antonio?
Yes.
Okay. Okay. I was born here, but I'm from San Antonio now.
6 minutes.
In August, it gets hot in San Antonio, right?
Yes.
So if a law enforcement officer comes in here and says, just came in from outside and it was snowing. Leaving just because he's a police officer. I think your common sense would be number 16, I believe. Okay, you work for the city of San Antonio, correct? Anything about the nature of the job that make it difficult for you to be fair and impartial. So number 30. Okay. You're a instructor at college?
I was having a professor at full-time.
Okay. And what do you teach?
I teach architectural design and graphics.
nothing about the nature of your job, make it difficult for you to. Thank you, sir. Number 2. Okay. Your nurse,
Nurse practitioner.
okay, RN,
And B, it's same sex, it's fine.
okay. Not that great with the initiative. Okay, anything about your work, nature make it difficult or impossible for you to serve?
No, sir.
Okay.
5 minutes.
Okay, I have 5 minutes. In this case, in murder case, there's a very good chance that you're going to see graphic pictures of a person, of a human. Any of you feel that just because the pictures that you may see are graphic in detail, or could be, I guess, considered disturbing in a way, would that put you in a position that you feel that you could not be fair and impartial because there's a lot of graphic pictures that you may have to look? Anybody feel that? Okay, number 58, number 49. I'm sorry, that's it. 58, right? Oh, number 13. So number here, 58. See, with my glasses sometimes it's glare, I see glare right out. That's what it looks like. Anybody else? All right. Number 45. I got a few seconds for that. All right, you're a news production man. What that mean, like KSAT, or was that? WOAI and TV. Okay, so in terms of the news that we see, do you help put those clips together? How does that?
I'm a newscast director.
Okay,
I'm behind the scenes in the program, telling everybody what to do.
so you cover stories like these types of stories, or if somebody gets hurt or accident, those types of things? Okay, and do you feel that is anything about the nature of your job that make it difficult and impossible for you to say? Yeah. Thank you, sir. All right. Number 46. Okay.
Yes, sir.
Military, you're still in the military or you're out?
So I'm in the reserves. Okay, so I'm transitioning right now.
Oh. Are you an officer or non-enlisted? So you ever been involved in anything like court martials?
No.
The officers do that, right?
Well. Yeah, I mean, yeah, the officers would be the attorneys.
Right.
Yeah.
All right. Okay, just wanted to make sure. It's nothing about your work that would make it difficult for you to serve.
No, sir.
Okay. Number 52. Okay, you're a teacher also?
Yes,
All right. And you've been on a criminal jury before?
yes.
All right. And do you is it anything about that experience, your former experience on jury, that make it difficult and possible for you? Yes. All right, thank you, sir. All right, number 60. Okay. Now, you have someone in your family that's law enforcement that retired or no? Do you have anyone in your family that's law enforcement? Okay. All right, I just wanted to make sure. Okay, thank you. number. I called 50 already. Who's 50? 50, number 50. Do you have relatives that's involved in law enforcement?
Yes, my brother.
Your brother? Here in San Antonio,
Correct.
SAPD. All right, is he, is ever discussing his work with you? from time to time?
No, I don't know his name, but he does live 5 miles away from me. This is questioning me.
Okay. Do you feel anything, because, you have a brother that's involved in SAPD that make you, anything make you,
No,
can be fair and impartial?
they're very diverse, so we're twins and we're like diverse twice, so we're very opposite.
Okay.
So, no, I don't think so.
Okay. All right, thank you.
Time. Council, that's time.
Time, yeah.
Yes.
Well, I thank you all very much.
All right, so ladies and gentlemen, I'm gonna have you all step out in the hallway and we'll call you back in by 1:40. Everyone who's in the box, you need to take all your personal items with you.
Your numbers behind, please.